Hello, class, and welcome to the Week 6 lecture for Introduction to Law. This week we will be discussing Chapters 11 and 12 of your textbook. The material covered will include estates and probate and property law. Probate law and estate law is interested in the question of what happens to a person's assets when they die. Very few citizens die with no assets, no debt, and no legal heirs. Final illnesses and even burial expenses can be substantial. The first issue we should talk about in some detail is guardianship. Individuals who cannot adequately manage their own financial and personal affairs for any reason may require an appointed guardian. The probate court can handle both decedent estates and guardianships. Unlike a typical civil litigation, probate court cases do not always have, but can have, adversarial parties represented by attorneys, and in fact a case may be entirely handled by one attorney, or can also be handled by a large number of attorneys. The parties that are entitled to speak in probate actions include any party with a potential interest in the estate. This would include potential heirs, creditors, and any person that wished to contest the validity of a will or the jurisdiction of the court. And in the case of minors who need guardianship, courts may intervene on a temporary or permanent basis to protect the interests of the minor. When the government intervenes on behalf of a minor, it may supersede the right of the parent or parents and assume responsibility for making decisions in the best interests of the minor child. And in fact, if there is a dispute about who a guardian should be or as to the terms of a guardianship, the court may appoint a guardian ad litem, which is an attorney who is meant to represent the interests of the child, and the guardian ad litem would be objective to dispute and review the circumstances in terms of the best interests of the individual at issue. That guardian then makes a recommendation as to what is in the best interest of the disabled person or minor. The first area of law that we will discuss in connection with the distribution of assets after death refers to intestate succession. Intestate succession means that a person has died without a will. The state in this case has prepared a set of laws that detail how assets will be distributed, and this is meant to approximate what the average dead person would prefer to see happen to their assets. Although obviously one obvious disadvantage to this is that not living a valid will means that the state may, or the intestate law may, differ from what the deceased person would have preferred had they written this down in a will. Historically, states use something called per capita distribution. This started by identifying all living relatives of the deceased, and then the assets of the deceased that remain after probate were divided equally among the number of survivors. This approach has faded in view, and more recently, states have been moving towards per stirpes distribution. In this method, all surviving legal heirs are identified, and entitlement to receive the estate in percentage depend on the proximity of the relationship. Those within a closer degree of relationship or generation will inherit over and possibly to the exclusion of more distant relatives. And although state statutes may vary, the common thread of per stirpes is that whether a person inherits depends on the proximity of their relationship to the deceased and how many other persons have the same relationship. Generally, under per stirpes, the estate is distributed first to spouses and descendants, that is, children. If there are none, then it is distributed to ascendants, such as parents and grandparents, and across the siblings, brothers and sisters, and then to descendants of the siblings, nieces and nephews. If there are no living relatives at these levels, it proceeds to ascendants such as aunts and uncles and their descendants, cousins. Depending on the limit set by the statute, this may continue for several degrees of family relation. If there isn't a sufficient affinity among any relatives, then it will go to the state. And here are some common rules that are used for intestate succession. A surviving spouse and children, all born to the surviving spouse and deceased. In this one, the spouse receives a lump sum of money and an additional percentage of the estate, and the children receive the entire remaining percentage to be distributed equally. The surviving spouse and children, some of all of whom who are not the children of the surviving spouse, the spouse and child receive one half of the estate each. If there is more than one child, the one half will be divided equally among the number of children. The third situation is a surviving spouse, no children, surviving parents or siblings or both, or children of siblings. The surviving spouse in this case is often entitled to a lump sum of cash and one half of the estate. Parents and siblings each take an equal share of the remaining one half. If the sibling is deceased but leaves children, then the children each take an equal share of what would have been the sibling's share. And finally, surviving parents, siblings, and children of siblings, the entire estate would be distributed on the same basis as indicated in item C. And as indicated, the shares are divided based on categories of living relatives. Descendants of deceased individual with close relationship may split the share of the deceased ascendant heir. And what that sentence means is that, for example, if you have no children or spouse and you have dead parents, then ordinarily the sum, for example, would go to your parents, but since they are not alive, then it could be distributed equally among your brother and sisters. And a spouse is considered to be a blood relative for purposes of inheritance, even though the relationship is a legal one. And adopted children are also considered as a natural child of the parent. And states are divided, though, as whether the fact of adoption cuts off that child's rights to any assets from their natural parent. Moving on, it is time to discuss testate succession. When an estate is distributed based on the terms of a legally recognized testamentary document such as a will, it is referred to as testate succession. For a will can be used as the instrument to distribute an estate, it must be declared a valid will. Every state has statutes that dictate the exact procedure for the preparation of a will. If the procedure is not followed, or if significant irregularities are present, the will may be declared invalid and the estate distributed by intestate succession. Most states require that the will be in writing. Although oral wills are permitted in some states, it generally must be shown at the time of the oral will the deceased believed death to be imminent and the terms of the will were declared to witnesses who would not stand to inherit. Under requirements for a written will, it is required that the testator sign the will with the knowledge that the instrument being signed is a declaration of intent for distribution of assets upon death. It also must be shown that the testator have capacity, and capacity in this context means that the testator must be shown to have understood the extent and value of the estate and the effect of a will, that is, giving the estate to specified others upon death. If it is established that the testator prepared the will under some mental impairment that would prevent full comprehension of the will's effects, then the testator may be considered not to have the requisite capacity. Additionally, if a testator prepares the terms of the will under false information, undue influence, fraud, or some other factor that would impede the ability to exercise a voluntary testamentary document, the testator would be considered to have lacked capacity. Additionally, another element that must be shown is that the will must be witnessed, and it must be established that the document was voluntarily signed by the testator. It does not require that the witnesses know the contents of what they are signing. Witnesses generally do not have to sign in the presence of one another so long as they were each present when the testator signed the document or acknowledged the testator's signature. When there are several pages, there is an opportunity for unscrupulous individuals to insert additional terms in the will. Therefore, any will of multiple pages should indicate on each page the page number and the total number of pages. This decreases the chances of alterations, and many courts prefer that the testator and witness initial each page of the will and affix their signature to the final page of the document. It should be noted that any will that fails to meet all of these elements will not be enforced by the court typically, and in these cases, the courts will resort to intestate succession to divide the will, which we have previously discussed. Some wills mention other documents and incorporate the terms of these documents by reference to the document and by indicating the intent that the document become part of the will. The documents to which the will makes reference are incorporated into the terms of the will as if they were actually a physical part of the will. To incorporate another document by reference, it is required by statute that the document already existed at the time the will was created and that it referred to the will within its contents. This prevents persons from creating the document to serve their own purposes after the will is executed and the testator is deceased. To conclude our discussion of estates, we need to talk about modifying wills, revoking wills, and republishing wills. Wills can be modified by a codicil, or in addition to an existing will. It is necessary that a codicil incorporate by reference the pre-existing will. Otherwise, the codicil may be considered to be a complete and new will. All of the requirements necessary for a valid will are required of a codicil. And a codicil should not contradict the terms of a previous will. This is necessary to accomplish the objective of the testator that an entirely new will should be created. Will revocation becomes necessary when the intent of the testator changes with respect to distribution of assets on death. When a new will is executed, all previous wills are considered to be revoked and invalid because they no longer reflect the intent of the testator. Even if the testator does not execute a new will, the old will can be revoked. If not revoked by a written document, then the testator can physically destroy or obliterate the will. It is not usually required that the will be totally destroyed. Rather, it need only be shown by the condition of the will and acts of the testator that the destruction was intended. Some instances after revocation, a testator will seek to have a prior will made valid again. This can occur in several ways. When a new will is executed and contain a statement that if it declared invalid, the old will should be reinstated. This prevents automatic intestate succession if the new will is defective. Another method to reinstate or republish is for the testator to say and do acts in the presence of witnesses that clearly establish the intent that the former will be revised. And with that, we will conclude our discussion of estates. It should be noted that there is some further material in the chapter that you should be aware of, and this includes the material on will contests and the procedures for probating a will. Moving on, it is time to discuss the Chapter 12 material on property law. There are three major divisions of property that we discuss. Real property, which deals with lands and things attached to land. Personal property, which are tangible items that are not land or attached to land. And intellectual property, which includes patents, copyrights, trademarks, and other such items. The legal definition of property is concerned with rights. It's not physically the item or parcel of land, rather it is the bundle of rights that comes from owning property. In legal terms, when discussing this interest in property, the focus is on the type of right to possess, control, or own the item in question rather than on the item itself. As discussed earlier, real property is land or that which is attached to land in such a way that it is permanent, fixed, and immovable. And the law of real property governs all that is part of the land naturally or as a result of it being artificially incorporated into the land in a permanent way. The type of property ownership is divided into various types, and we just use the term freehold estate to describe ownership and related interests in land, and this has to be distinguished from non-freehold estates such as lease or rental agreements where you have temporary right to the land via contract. Also, these types of estates can be further divided into different types. The most common type of ownership in the United States is fee simple, which means that the land is owned for perpetual duration with the unlimited right to do whatever one wishes with land that they owe in fee simple. The next type of estate we need to discuss is a life estate. A life estate gives the holder the right to control property for the holder's lifetime without interference. Such an estate includes the right to do all things an owner in fee simple could do, with two notable exceptions. The property cannot be disposed of or sold or given away, or treated in such a way to ruin it for its usual purpose, known as wasting. With a life estate, ordinarily there will be a provision on who the land goes to upon the death of the person who owns the life estate, known as the life tenant. And this life tenant would be this person who would get the land after the life tenant's death would be able to bring a suit to prevent the property from being wasted. That life estate holder would only be able to give away their interest to the extent they have it, which means by their life. These are not ordinarily favored by law, as they really do harm the marketability of a piece of property, as all potential people who stand to get the property after the death of the life tenant would have to consent to make a permanent alteration of the land, and the life tenant interest can be at odds with the people that would stand to inherit, as the life tenant has no interest in the land once they die. Another type of leasehold is a defeasible fee, and those that are in the ownership on the happening of a certain event at which time the property passed to a named person. Some of these estates create future interest in parties who don't currently have any rights in the land. One type of these is a remainder interest, and it is created automatically at the end of another. So, for example, if you give one surviving spouse a life estate, the person who would stand to inherit would have a remainder interest. Additionally, land may be owned, and these estates may be owned by multiple people. One type of situation this occurs is tenancy in common. Tenants in common cannot agree. This is the default mode of ownership of a tract of real property. In this type, each owner has an undivided interest in the property, which means that they have an equal share in every part of the property. The undivided interest guarantees that no owner has a better portion of the property. Each owner has a balanced interest in both the positive and negative aspects of the property as a whole, and the percentage of the interest is equal to the percentage of ownership. And in addition, their undivided interest, the tenants in common may do all things with their interest as if they owned the property entirely. The only limitation is they cannot act in a way as to interfere with the rights of the other tenants in common. And when there's a disagreement among these tenants in common, then a legal action for partition that may be brought by one of the tenants, where the court will divide the land into individual portions and create an individually owned portion for each party. The primary distinguishing characteristics of the joint tenancy, which is the next type of multiple party ownership we will discuss, is that it includes the right of survivorship. This means that upon the death of a joint tenant, the property automatically becomes owned in full by the other joint tenant. And to create this type of ownership in common, it must be specified in the instrument that transfers the property, that is the deed, and joint tenancy will generally include that right of survivorship language in that transferring document. And the right of survivorship will restrict a party's interest from flowing naturally to the descendants. Because of this, it is necessary for a party involved in a joint tenancy to formally agree from the outset that there is an intent to create such an interest. In this way, heirs are protected from losing an interest in the property when it is not the desire of the deceased to do so. And to create one, there must be what is called 4 unities, which means that each tenant must have received his or her interest in the property at the same moment, the unity of time. The interest for each must come from the same source, namely the previous owner, which is the unity of title. Each tenant must have identical rights regarding the property, such as an equal share, which is the unity of interest, and each party must have an undivided interest in the land itself, which is the unity of possession. In some states, the statute requires that the intent for the right of survivorship be specified in the conveying instrument, normally the deed. The basic rights of these tenants are fundamentally identical to that of the tenants in common. It's important to note that one use of these actually, referring back to our material on probates and estate, is this can avoid having to probate the asset that's owed in a joint tenancy. As with other type of land, it would have to go through a court's probating procedure before the party that you wish to receive the land would get it. With a joint tenancy, ordinarily the land will automatically transfer that party, avoiding what can sometimes be a rather timely probate process. The final kind of joint ownership situation we can touch on is the tenancy in the entirety. I don't want to spend too much time on this. Basically, it's created in a situation in which the husband and wife are the joint tenants. It includes all the things of a joint tenancy, plus it is much more difficult to transfer the property unilaterally. And as we discussed earlier, property includes in it the concept of a bundle of rights. Some of these rights protect incorporeal interests, and the ones here that we want to talk about are the right of quiet enjoyment, the right of possession and use free from interference, and easements. Basically, it means that a person has a right to be secure in their property without being disturbed by the action of others. A particular note, though, is the law of easements, which is the legal rights of non-owners to affect the use of the owner's real property. Essentially, this area of law permits the holder of an easement a limited right of interference with the property otherwise protected by the right of quiet enjoyment. For example, one could have an easement over the over land for access across the land in order to maybe get to a parcel of land that doesn't have road access. And these easements can be created in many ways. And you should refer to your textbook for more material on how exactly easements can be created or extinguished. And to conclude our discussion of real property, before moving on to personal property, I'd like to discuss the doctrine of adverse possession. This will be related to some of your assignments. Adverse possession is recognized as a means of attaining title to property without consent or voluntary transfer by the owner when certain conditions are met. The reasoning behind adverse possession is that the government encourages the productive use of land, and if the owner does not productively use the land and does not protect the right to possess owned property, then the law will recognize ownership in one who will. That is one reason justifying adverse possession. Perhaps an even more significant reason that adverse possession law exists is it gives title certainty in certain situations where it may be difficult to do a good title search. So where somebody has appeared to own and use property for a long time, if they sell that to another person, that person should be able to use the fact that the seller has been using the property in a productive manner to be secure in their purchase of the property. Although the precise requirements of adverse possession differ from state to state, there are 4 elements that normally must be shown in order to acquire title by adverse possession. And these are open and notorious possession, which requires that the person seeking title actually possess the property. The adverse possessor must act in a way such as that others, including an alert property owner, would perceive such actions as 1, exercising control over the entire property. The second element is continuous possession, which is designed to prevent transients and squatters from claiming title to property. The law gives title to persons who show ongoing concern for the property. Therefore, it is necessary to exercise control or possession of the property in a way that is perceived as continuous. Abandonment for any significant time will prevent this element from being proven. The third is exclusive possession, which is necessary to show that the person claiming the title by adverse possession acted in a way to exclude others from possessing the property until all the elements are sufficiently met. This does not apply to the original owner. The true owner of the property who becomes aware of somebody else possessing the property can retrieve it. However, after the statutory period, the adverse possessor has the right to exclude others from the property. And the final one is adequate duration of possession. These differ by state and can range from anywhere from 5 to 20 years to gain title. It may also differ within states based on the circumstances of the adverse possession. For example, if somebody is claiming adverse possession through some sort of title document, which perhaps wasn't valid but only becomes valid through the satisfaction of these elements, then the duration may be shorter, perhaps 5 years, and if somebody is just squatting on a piece of land with hopes of adversely possessing it for an extended period of time, that may be ratcheted up to require 20 years. And it's important to note that most states and the federal government do not allow adverse possession of federal or state lands. And that it also is important to note that it can be established through different people possessing the property during the specified period, and this is known as tacking. And when a statute prevents tacking, it requires succeeding owners to be descendants or heirs, a spouse, or someone who was voluntarily granted possession during the life of the first adverse possessor. And that will conclude our discussion of real property. It should be noted that there are many areas of real property that we only briefly covered, and I would encourage you to go backwards and refer to the material on leasehold estates, which is renting property, licenses, condominium ownership, and fixtures. Moving on, I'd like to conclude the Week 6 lecture with a brief discussion of personal and intellectual property. Personal property includes money, goods, and movable tangible items. And legally, personal property may be sold, lent, given, lost, stolen, abandoned, or altered. The first issue of personal property we should discuss is bailment, which is a party having possession of personal property, known as the bailor, temporarily delivers the possession of the property to another party, the bailee. The delivery is made for a specific purpose or as part of a contract with the understanding that the property will be cared for and returned to the original party on demand. A compensated bailor is expected to take greater steps than a mere ordinary care to protect the property, and the compensation is at least for the insured well-being of the property. One common bailment, for example, may be a coat check, where you own a coat, you're the bailer, you give it to the coat check person, who is the bailee, who should exercise some sort of reasonable care to keep your coat secure. And the elements of a bailment are personal property transferred by a party with the right of possession to a second party for a specific purpose or as part of the terms of a contract, that the property will be protected, and that the original party has the right to reclaim the property. And in some cases, an additional element requires that compensation must be given in return for some act pertaining to the property. It should be noted that one of the bundle of rights that exists with personal property is the right to use, own, and possess property. When these rights are infringed, there are several actions that can be taken in order to recover either the property itself or the value of property. The first one of these I'd like to discuss is conversion, and this basis for an action when one party receives possession of the property of another and wrongfully holds it. This can occur in one of two ways. In the first instance, a party may seize control of the property without permission, and in the second or more common interest, a party may refuse to return property that was previously bailed. If the owner approves conversion, the property may be recovered, or if the property has been altered or disposed of, its value may be recovered. If the property is returned, the owner may also recover the fair market value of the use of the property during the time he or she was deprived of it. The next one is trespass to chattels. This is when a party substantially interferes with another's possession or ownership of property. The primary difference between conversion and trespass to chattels is that in the latter there is no need to show intent of the second party to exercise control of the property. It is only necessary to show that the second party dispossessed the first property of his or her property permanently or for a substantial period of time. As in the action for conversion, the party claiming trespass can claim the fair market value of the property. If the property was ultimately returned, then the claim can still be made for the fair market value of its use during the period the true owner was denied access to the property. And the final action that I want to talk about in discussion with personal property is the action for replevin, which is to regain possession of the actual property that was wrongfully taken, not its value. This type of action is an equity action based on a claim that money damages are insufficient to remedy the wrong. And to bring this action, the plaintiff must show that they have a right of immediate possession. The property in issue must be personal property, and the property must be unlawfully possessed and detained by the defendant at the time the action is commenced. Finally, we will end with a discussion of intellectual property, and this is something that is literally created mentally and recorded in some physical manner. And there are two types, including inventions and artistic creations. Patents infect inventions and equipment designs, and copyright protects artistic creations. Symbols and logos are a third type that are protected through trademark law. And with that discussion, that concludes the Week 6 lecture, and I will see you all next week.